Ladies and gentlemen, the NHI Act has been deemed unconstitutional and illegal, or maybe it hasn't. But before we get to that, can I kindly remind you that nearly 90% of our audience is unsubscribed. And on our journey to 100,000 subscribers, it would greatly help us if you would do the usual YouTube things, like, share, and subscribe. But onto the video. On Wednesday, the 24th of July, the High Court ruled that sections 36 to 40 of the National Health Insurance Act were illegal and unconstitutional. Now, before we get into the specifics of what was illegal and unconstitutional, let's just have a quick revisit of the National Health Insurance Act. The Act itself proposes to centralize all control over the National Health Service into the hands of the government. The government would then be able to procure services from both private and public partnership deals. They could set the tariffs, they could set who gets licensing is a key point, and they could regulate basically the entire National Health Service through their central command, the central command being directly in the hands of the Minister of Health. Now, this itself has caused a lot of condemnation. A number of individuals who have been unhappy about it claim that it's nothing more than let's call it a grab, a property grab, because what it effectively does is it says you have a private business, it's now going to be public, it's going to be in the hands of the government. You might not fully expropriate it, but we'll basically tell you how you can run it, we'll pay you, and we'll also say how much you can get paid. We'll also say where you can work and in what areas you can work. Now, that has caused the ire of many medical practitioners who claim that what it does is it limits the doctor's ability to choose the areas of practice that they want to be in. Some don't want to be general practitioners. Maybe they want to be radiologists. Who knows? But what this effectively says is that the government will dictate which areas that you specialize in, and some don't want to work in government hospitals. Maybe they want to specialize in private practice. Well, according to this act, they wouldn't really be able to choose. The government would say, according to a certificate of needs. Now, the national health insurance would then all be paid for via a levy off everybody's PAYE. Remember that only a small amount of individuals in South Africa pay a form of PAYE, and so this tax itself has led many to say that the act is unimplementable given the current finances of the country. So why did it actually get passed? Well, there's a number of reasons why that may have happened. This was something that was under constant consideration during the 6th administration, and might I remind you, ladies and gentlemen, this is something that Jacob Zuma, underneath the 4th and 5th administrations, was never keen on. This was a Ramaphosa policy. Now, you may notice that there's a white gentleman in the thumbnail. This is the Deputy Director General of the Health Services, Nicholas Crisp. He's the actual brainchild of the NHI. He's the guy who's pushing it forward. Now, some argued that the reason the government was pursuing this program was to help them win the last elections. And interestingly enough, it was signed at the 11th hour, just before the eve of the elections, with the idea that it might be able to get the ANC an additional 5% of the vote. But for those of you who were paying attention to the vote, it actually cost the ANC 5% of the vote. It was actually something they did to try to get them electoral support, but it actually ultimately ended up costing them the election. So to a degree, you may argue that in its current format, NHI is no longer popular. Going then on to the Act itself and what the High Court has ruled. So the High Court has effectively ruled that sections 36 to 40 of the Act are unconstitutional, and they will now have 14 days to refer this to the Constitutional Court to say whether or not their finding was correct or invalid. Now, what this specifically targets is the certificate of need. So what the certificate of need does is allows the government to dictate who can open a private business or not, and what they can practice in and where they can practice in. So if you were an individual who wanted to open a general practitioner in Cape Town, the government could effectively say, too many in Cape Town, how about Limpopo? You can open one in Limpopo because we have a need in the rural village. Now this, the government says, was an important part of NHI because it would mean that there would be universal health coverage around the country and everybody would be given access to medical services. But if you're the individual who wants to live in Cape Town and you're being made to live in Limpopo, you might not be so keen. So the actual judge himself said the reason that this was unconstitutional is because it allowed the government to basically state where you could live and what you could do which would limit your ability to live where you want and choose the profession that you want, which are both protected by the Constitution. Others said that this would basically amount to an expropriation of people's private medical practices and allow the government to basically control those practices on behalf of the medical practitioner, which they claimed was a form of expropriation without compensation. One other reason that the certificate of need was problematic is that it was too broadly defined. It basically covered anything that was deemed to be a medical establishment. Anything from a doctor's surgery to a hospital to potentially even your local pharmacy, possibly even the local health food shop. So, come Thursday, the Dr. Aaron, who's the current Minister of Health, he came out and basically said he was highly concerned about the sections of the Act that were deemed illegal. But he didn't actually think that it impacted the Act as a whole. Now, this is in contrast to what Centralization says. Centralization says the judgment basically renders the entire Act unconstitutional because it shows that there is no desire and no constitutional allowance for central planning of the health service. Now, Dr. Aaron says that whilst he's deeply concerned, it also doesn't change the process around through which the NHI will operate. Remember that a key functionality of the NHI is centralized funding and centralized paying for services. It's basically the centralized fund, which is one of the key critiques of the NHI as a whole, which is the idea that if you have this lovely pot of money, it's going to be looted, pretty much like everything else gets looted. So what does this actually mean? Well, Action SA says that this shows that the bureaucracy of the state, which is in the hands of the cumbersome and already overworked Department of Health, isn't really favored by anybody in the health industry, nor the courts. By rendering the certificate of need unconstitutional, it means that centralized planning as a whole has failed when it comes through to the NHI. According to Derek Harmon, the CEO of Centralization, it also shows that the attempt to nationalize healthcare in the country has basically failed, and all healthcare practitioners can now rest a little bit easy knowing that centralization by the state will not occur. Now, I don't know about the rest of you, but I myself saw a number of doctors get very concerned when the NHI was signed. The DA themselves put out an announcement that basically said that they were inundated with queries and concerns from doctors immediately post the signing of the Act. And it was one of the key elements that many South Africans highlighted when being concerned about the current state of their country. So should we rest easy? Well, according to Wits University professor Musa, no, you shouldn't rest easy. Because according to him, this may mean that the certificate of need is unconstitutional, but all that needs to be done is that the licensing criteria or the licensing process used to license administrations just needs to change, but it doesn't change the fundamental thesis of the Act itself, which is the centralization of funds. A director of the Rural Health Advocacy Program, Russell Renberg, said that he doesn't believe that this will impact the NHI in the slightest. And obviously the health minister, Dr. Aaron, basically says this doesn't change the NHI in the slightest. The Constitution still requires that there should be a statutory mandate for the regulation of the healthcare establishments, which is being done by the Department of Health, and they will continue with their mandate. So what does this actually mean for all of us? Has it been defeated? Well, possibly and possibly not. We don't really know. Obviously, this will go before the Constitutional Court, and it doesn't really strike down the biggest problem that we see in the Act itself. Some say that it shows that the idea behind centralized planning is moot. You can't do it when you read the Act in its entirety. Others say that the judgment only relates to those specific sections. So what will happen next? Well, it will go before the Constitutional Court in the next 14 days. Hopefully we'll get some clarity. Until then, we can all just hope that maybe this is the first blow against NHI, and NHI in its current form will not come through to fruition. It doesn't mean that we don't want there to see health sector reforms. I think everybody agrees that there needs to be serious health sector reforms in the country as a whole. But what they can't do is they can't centralize everything into the hands of the government when the government has shown itself to be incapable. But that's just my views. Let me know your views in the comment sections below. Until next time, see you again.